Hello and welcome to the UNB Law Podcast. My name is Michael Marin and I'm the Dean of Law at UNB. We begin by recognizing and respectfully acknowledging that the UNB Law community stands on the unsurrendered and unceded traditional land of Wolastoqiyik. Today we're doing something special with the UNB Law Podcast. This episode is going to feature UNB Law alumna Janet Hoyt, who graduated from UNB Law in 1984. She will be interviewing her father, Bill Hoyt, a former Chief Justice of the New Brunswick Court of Appeal. Janet is a true champion of UNB Law. She serves on the Board of Governors of UNB. She serves on several committees as part of the law school and has been instrumental in developing our vision for the future. She is a former practicing lawyer and someone who has devoted her career to helping law students and legal professionals achieve their career goals. She currently works for McCarthy Tétrault in Toronto and worked for many years at another national firm, becoming a leader in the talent management space in the legal profession. So without further ado, enjoy this very special episode of the UNB Law Podcast.
Hello, and welcome to UNB's ongoing series of podcasts. My name is Janet Hoyt. I am a proud New Brunswicker and a proud graduate of UNB Law School. I currently sit on the Board of Governors and was a member of the recent Law School Strategic Planning Committee, and I will continue to stay involved in the implementation of that plan. I have deep affection for the law school. Dean Marin asked me to guest host this podcast, and I am delighted to do so. I have the privilege and the honor of interviewing my father, the former Chief Justice of New Brunswick, the Honorable William Hoyt. Dad to me, Bill to most others. Technically speaking, he is not a UNB law grad. He went to Cambridge. We'll talk about that later. But he did get an honorary degree from UNB in 1998, so I think that aptly qualifies him as an alumni. My father has been described to me by many as a legal giant. Of course, I'm biased, but I do think he has had a career in law, and I look forward to him sharing his past and some career highlights with us today. So just by way of introduction, to save Dad's voice, my father was born in St. John on September the 13th, 1930. He was born into a railway family. His father, my grandfather, his father, worked on the CP Rail, so they moved around quite a bit. He lived in Fredericton Junction for the first few years of his life, and then my grandfather was moved to Brownville Junction in Maine, where he did his middle school, and then he was moved yet again, last time, to Woodstock, New Brunswick, where Dad did high school. That is where he met his best friend, Turney Jones, and I'm sure you're going to hear some stories there. And they went off to Acadia together with some other notable UN New Brunswickers, Dick Hatfield, Arthur and Jack Irving, Wallace and Harrison McCain, John Clark. It was quite a graduating class. Dad got his BA and his MA in history from Acadia. And then he actually came to UNB to start his PhD, but shifted gears midway and decided to pursue law. And that's when he went off to Cambridge University, specifically Emmanuel College. And he was there, he studied law at Cambridge from 1954 to 1956. After graduating from Cambridge, he came back to Woodstock and articled for his friend Turney Jones. But Dad always wanted to live and practice in New Brunswick. So he came to Fredericton and he joined Ralph and Arthur Limerick. Limerick and Limerick became Limerick and Hoyt, which eventually became Hoyt, Mockler, Allen, and Dixon, a place I spent lots of time at. Dad enjoyed an interesting and successful career in Fredericton, which he will talk about today. And he was appointed to the Court of Queen's Bench in the summer of 1981. Then he moved back to Fredericton to the Court of Appeal in 1984. I think these dates are right. And he was appointed Chief Justice in 1993. He resigned as chief in 1998 to take on the Bloody Sunday inquiry, another topic we'll cover today. So I think with no further delay, I will get started. I hope the technology works. I'm in Toronto and Dad is in Fredericton. So I'm going to start with a question. So first question. So you were headed, Dad, you were headed down the academia road, pursuing your interest in your studies in history. What changed and why law?
Well, when I came to UNB to start which would have been the start of my PhD course, I was a little bit torn even then between law and becoming an academic. And I found that I didn't have the discipline to work on my own to the extent I felt necessary. In those days, you had to have a PhD to go any distance in academia. And I was worried that I would get just so far and perhaps not make the final cut and get a PhD. So I thought, where law had always been an interest of mine as well, I thought law would be a better choice for me, because in law, deadlines are imposed by other people. You have to meet them 10 days to do this, 20 days to do that if you're in court, or your clients put you under pressure to finish something with a certain length of time. So it just makes one much more or at least it did make me much more self-disciplined than if I had just been given a cubicle and a pencil and a piece of paper to write a thesis. I never did finish the thesis at UNB. I worked quite hard in getting the material together, but I never actually got pen to paper. So I think it was a good choice not to have continued down that road.
And why did you choose Cambridge?
Well, a couple of reasons. After I finished Acadia, a friend and I spent a half a year in Europe traveling around, a lot of it in the UK, in England, and Scotland, anyway. And it sort of intrigued me. The reason was I could get a degree in law there in 2 years, where in a Canadian law school at that time, and I guess now, it's 3 years. So I'd taken a year, I'd really lost a year by fiddling around with my PhD prospects at UNB, and another year when my friend and I went overseas. So I thought that I'd better and I think my mother and father had something to do with that too. So get on with my life, decide what I wanted to do. So the two of them were motivating factors to go to Cambridge. Actually, I had applied just as a backstop to Dal and had been accepted. And if I hadn't got accepted at Cambridge, I would have gone to Dal, and only would have taken me another year to get to qualify. So that's how I made my decision to go into law. As I say, it was always a secondary interest of mine anyway. And in fact, I almost at Acadia, almost at one time, after the second year at Acadia, thought I might go to Dal, because in those days you could get in to law school with 2 years of undergraduate work and go right into first year law. So, but of course that would have that would have permitted me to be admitted to the bar about 4 or 5 years sooner than I was, but I didn't choose that. I was enjoying myself at Acadia, both the work and the university side of Acadia, the social side, the sporting side. So I didn't think too seriously of doing the 2 years and Dal route.
And just as a side note, sorry, is that just as a side note, what was there was one highlight of that trip with you and your friend, and I can't remember what year that was. What tell everybody about that highlight.
That was in 53. Well, there were a number in 1953. There were a number of sort of highlights, but I'd been involved at Acadia with what was then called the National Federation of Canadian University Students, and was the chairman of the Acadia branch of NIFCUS, as it was called for short. And there was a big controversy going on at the time about whether the Spanish students should be represented it was decided that NIFCUS should make an inquiry before they made a decision. So my friend and I were accredited as so-called ambassadors to Europe from NIFCUS for that 6-month period. And included in that, during that time, was the coronation. And so my friend and I went to the coronation in, I think it was June 1953.
Queen Elizabeth, yeah.
And I later had occasion to meet the Queen, and I told her about that experience.
Anything more on that, or do you want to move on?
We'll move on. I got my degree from Cambridge, came back and practiced, came back and did my articles, again with Attorney Jones in Woodstock, and then was hired by Arthur and Ralph Limerick here in Fredericton. They had a general practice, good general practice, but they never thought of expanding it. They were quite satisfied with their clientele, the amount of work they were doing, and they were not ambitious financially. They were making a very good living with the work that they were doing, the two of them. So I was quite fortunate for them to hire me, actually. It was the first one that they had hired. And so I stayed there, of course. About 6 or 7 years after I arrived, they both left. Ralph to become a Court of Appeal judge, and Arthur to become a judge, general counsel to the New Brunswick Power. So that left me with a rather big practice on my hands with very little experience to run it. So I did, I guess what you'd say, recruiting now, and we ended up, Pete Mockler, Keith Allen and Ray Dixon and I, and later Lorraine King, formed a partnership which became known as Hoyt, Mockler, Allen, Dixon, and we practiced together until 1981 when I became a judge here in Fredericton. And we expanded the firm. I think at the time I left, there were 10 or 11 lawyers in the firm. I don't remember exactly, but I think around that money. And
I do remember you telling me that when you came back, you were recruited to teach at the law school. I think it was the year that the law school moved from St. John to Somerville House on Waterloo Row in Fredericton. And I believe you taught family law. So how did that come around? And maybe you can tell us a little bit about, the law school in the early 60s.
Well, the law school moved to Fredericton from St. John, you could say, and I think, if I'm not mistaken, it was just an accident of the timetable that I gave the first lecture in Fredericton to the law school. I've taught domestic relations. In those days, there were only 3 permanent professors, teachers at the law school. Bill Ryan was the dean. George McAllister and Jerry DeFlore were the other 2 members. Of course, they couldn't cover all the subjects, so some young Fredericton lawyers were recruited to fill fill that void. I was asked to do the domestic relations or family law lectures, which had been given in St. John by a part-time lecturer. The county court judge there, Judge Kirsten, gave them there. So I guess the permanent lecturers chose what subjects they wanted to teach, and then they would hire outside or lawyers from Fredericton to fill up the curricula. And they asked me to do the family law. Ron Stevenson and John McNair. I remember for sure there were others from the practice that taught particular courses in the law school. And you're right, it was a Somerville house, and the unusual an unusual feature of the law school then was that they only had 2 years, the second and third years combined, and an alternate year, second year courses would be given, and the following year, third year courses would be given. So if you came to law school, of course, it was possible to go right into law school in second year if you had taken, when it was in St. John, if you had taken sufficient law courses in Fredericton, the Fredericton campus. Joe Sears was the professor of law at the Fredericton campus. He gave sufficient courses that permitted a student that took them all to get his BA at UNB and then go down as second year at UNB Law School. I know that's what Pete Mockford and Keith Allen did, and a lot of them. So the law school, when it came to Fredericton, then gave first year every year, second and third year an alternate year. Whether there were enough dropouts in first year that it gave enough room in the classroom to do that or not, I don't know, but it certainly economized on staff a lot. So that's the way the law school operated when it first came to Fredericton. And I don't know how long the double year regime lasted, whether it lasted until it moved to its present location or whether it happened before that. I don't know that for sure.
Before we kind of shift to your judging years, I do remember you saying, I think when you were first admitted in Fredericton, you were the 27th lawyer.
Yeah, I was the 27th, and I don't think there was a lawyer after me admitted for about 2 or 3 years. Either Murray Kane or Lawrence Garvey was the next one, and I think that was a couple of years after I was. So we had a very small group of lawyers, and with a couple of exceptions, a very collegial group. Got together very well, got along very well. We had the Fredericton Barrister Society was more of a social club than anything else. In fact, it was almost entirely a social club.
Well, I do remember a few social gatherings at home on occasion.
I'm sure after the meetings, they always adjourned to someone's house afterwards to continue the festivities. But the Bear Society met, I think, I remember they met monthly, maybe every other month, I don't remember. But it was good in that people got together. And the other thing, the other social side of practice in those days, I was 57 when I was admitted, it wasn't as stressful as it is now. The offices didn't usually open till 9:30. Everyone took a lunch hour, most went home for lunch, and you always went out for coffee in the morning at 10:30 to the old Imperial Restaurant. You could walk in there anytime between 10 and 11:30 and find at least 4 or 5 or 6 lawyers seated drinking coffee, rotating in and out. And it was a much more relaxed environment in which to practice law than I gather it is now, even as it was when I left in 1981. first of all, you knew everyone, and although some of the older lawyers didn't participate in the coffee hour to the same extent that the younger lawyers did, they did on occasion. So it was a very easy place to practice. One took advantage of the other. It was a very nice place to practice.
Do you have anything do you want to talk about your practice before we talk about kind of?
It developed very nicely. For the first little while, Ralph Limerick had a reputation of being had a deservedly good reputation of being a very good criminal lawyer. So we did a lot of criminal work. Arthur was more of a civil lawyer. He was a very fine lawyer, and he did a lot of civil work. So we had more of a barrister or litigation practice than maybe some of the other firms did because of both Ralph and Arthur. But we did solicitors work too, of course, a lot of it. But there were no crown prosecutors in those days. Individual lawyers were retained for each particular case. And the way that it worked out was that the government of the day would pick lawyers of their persuasion to do the prosecutions. And when the government changed, then a new set of lawyers would take over the prosecutions, and the ones that were doing the prosecutions would then become defense lawyers. It was just a revolving door. So that's what happened in 1960. The government changed, and those of us that were liberals all of a sudden started doing prosecutions, or more prosecutions than we did before. We didn't do any before, instead of doing defense work. So it was because of the number involved, most of the senior lawyers didn't want to do that work anyway. So it was a great opportunity for young lawyers to be in court. And I know that I looked at some of my old diaries, and some days I'd be doing 2 or 3 motor vehicle cases a day, either prosecuting after 60 or defending before 60, and the odd criminal case as well. But to be on your feet a lot and getting good experience. From that, the practice developed into personal injury, started doing a lot of personal injury work, and then into civil and litigation. In fact, I even did 2 murder cases when I was in the 60s, prosecuted one and defended another. So it was a very dynamic time. You're always doing something for the first time, doing something new, and always something new, but doing it in a very good environment. And so that's what I did up until 1981, when I became a judge for Convention St. John. But we had a good practice.
Okay, so let's switch to kind of your judging year. So you were appointed to the Court of Queen's Bench in I think summer of 1981, and sworn in. I do remember this, sworn in just before I started law school. Exactly. And it was a bit of a bittersweet moment for me, I must confess. We were so happy and proud. Very happy and proud of you, for you and the family. But as I say, a bit sad for me. I'd always hoped and thought that someday we would be partners. But in the end, it all worked out. And I went on to have a rather interesting and unconventional career in law, and you certainly thrived as a judge. So in you lived and worked as a Queen's Bench judge in St. John from 81 to 84. And at that point, you came back to the Court of Appeal in Fredericton. Luckily, our husband was able to move back in there, and you became Chief Justice in 1993. So, why don't you, and I know you became, everyone says you were like a prolific producer, prolific writer. And I think we've counted them, or we've had all dad's written judgments consolidated into 3 volumes, and I think you wrote over 350. So, you know, do you want to talk about 1 or 2 of those decisions that would be of interest today?
Well, a couple of the cases I had as a lawyer, I probably should mention the first time that I went to the Supreme Court of Canada was a case involving promissory estoppel, boroughs and subsurface surveys. And I had a number of very interesting cases as a trial judge, as a lawyer. The iOS litigation in 1981 and 1971 and 1973, the Irving Combines case, which seemed to last forever. So there were some very interesting cases. And the thing about practice in those days is that outside lawyers, out of province lawyers, were not welcomed by judges. And so we depended a lot, for a lot of our work, referrals from Montreal and Toronto lawyers, which I gather doesn't happen so much now. But one of our Chief Justice Bridges, took a very dim view of the province lawyers and did everything he could to prevent them from appearing. So that made more work for us and more interesting work for us. As far as the Court of Queen's Bench in St. John, it was a busy court. It had been understaffed for about 2 years before, again, Attorney Jones and I were appointed at the same time to the court in St. John. And the whole 3 years that I was there, the court was under quite a bit of pressure to get itself up to date because it had been shorthanded for so long and such a busy court. One of the reasons was that one of the provincial court judges had a reputation of being a very stiff sentencer. So a lot of people chose trial by judge and jury rather than a judge in the provincial court to avoid that particular judge. So once he retired, I think the volume of work in the Court of Queen's Bench dropped quite a bit. But although I was only there 3 years, there was a lot of interesting cases at the time. During that time, I did four murder cases, including Mailman, who was a well-known figure in the underworld in St. John at the time. And so the other major case I did there was the St. John jail fire. 21 people were burned to death when a padded cell caught fire. And the guards couldn't get the people in the cells out. They were locked in. They burned to death, 21. And that was the longest trial I think I had as a civil trial. It lasted just a little more than a month, or around a month. So it was a busy time, but an exciting time because there were a lot of very interesting cases. So there are a lot of cases I could go on and on about, but I think we better move along.
Okay. So when you think back over the years, who were your mentors? You know, who did you go to for guidance?
Well, we didn't think of it as mentoring in those days as we do now. It's sort of a formal activity. Obviously, the 2 Limericks were the ones that I would get most guidance for, not only because of the proximity, but because we worked together, but because they were, particularly Arthur, was sort of a teacher by nature, and he was very good at explaining things. And Ralph was good too, but he was a little quicker and more impatient, whereas Arthur would spend time and make sure you understand the problem and the solution to it. Ralph would probably go right to the solution and jump over the reasoning to get there.
Right.
Both would be, but he'd be right, but he just wouldn't have the patience to take you through it. Or Arthur was just the opposite. Charlie Hughes was a bit like that too. He was another firm, but there was no one sort of claimed a proprietary interest in knowledge and practice and procedure, and you could talk to any lawyer about any particular problem as long as they were on the other side, or as long as you disguised it well enough that they didn't know who the person was. But Ralph and Arthur would be the main, would certainly be the main ones. The judges were very good. When we were first in Fredericton, the law library, of course, the Barrister's Law Library was in the same room almost, just a door apart from the Court of Appeal room. And the Court of Appeal judges knew they used the same library. And they were always very good, particularly Chief Justice McNair and Judge West were very patient with young lawyers and would sometimes, I think, Chief Justice McNair would almost do your work for you. He was such a good teacher and they weren't a busy court in those days. And I think they enjoyed doing it, and they particularly enjoyed young lawyers being around. But McNair and West were very good that way.
I do remember that you did a lot of work, and I think you had a lot of respect for Don Gillis in St. John. I just remember you and he seemed to be closely connected. We
were very closely connected, both opposing cases and cases together. When Art and Ralph's Limerick left close together, time together, it left me, as I say, quite high and dry with a lot of interesting cases, a lot of important cases and complicated cases. So I used counsel a lot before, particularly before Pete came. Pete was teaching at the law school at the time, so he had to honor his contract there. So there was a year that Ray and I were on our own, and I used counsel a lot, more than most lawyers from that experience would have done. And it was Don Gillis I usually use, although I use Toronto lawyers in some cases as well. I remember the Osler firm in particular I used, and Blake Castles, I used them some as well. And of course, during the iOS litigation, we came very close to a lot of firms outside the province, became quite well known, and that generated quite a bit of business in itself. But we did use outside lawyers because we had cases that we felt that were just a little too complicated and beyond our experience. Some lawyers are a little reluctant due to that because in a small town, it's sort of an admission that the population sort of think if you're a lawyer, you can do anything, and don't realize that there is a learning process involved. So I took advantage of that.
You also had a number of important roles in various legal, organizations, the Law Society, Canadian Bar. You're very involved in the Canadian Bar Association, the Canadian Judicial Council, the Cambridge Lectures, and the common thread in all of those really seems to have been your interest in continuing legal education and the need for that.
Well, that's right. I sort of took the view that if we didn't look after ourselves and keep ourselves up to date, that the province would move in and take over the profession and suggest how to govern. So I thought, as long as we were self-governing, that we should take it seriously and do continuing legal education, and also take our discipline matters very seriously. I was chairman of the discipline committee of the Barrister Society for a number of years, and we were lucky in New Brunswick, at least in those years, in that there weren't serious deficiencies in lawyers that require disciplining, but one of the advantages, of course, of the small bar is we had, I think there were 325 lawyers in the whole province, and I was admitted there might have been more than that. So you got to know, you could keep your eye on them. Arthur Limerick, by the way, was the secretary of the Law Society. So it wasn't long before I became involved in both society and the Canadian bar. And later on a more national scale, as you say, with the Canadian Committee for the Administration of Justice and the Cambridge Lectures.
I do want to ask you about one of the initiatives that you participated in through the Canadian Bar, and that was the committee that they struck that basically drafted and what eventually evolved to be the Canadian Constitution. I think it was called the Constitution Committee.
That's right.
That
was in the 80s, or in the 70s, I'm sorry, when Quebec separatism was at its height, and it was decided, the Canadian Bar decided that they should take an initiative to draft a new constitution. And a committee was struck, one member from each province, two from Quebec. And I was the Brunswick member of that committee, and it was a monumental job. We engaged Jerry Laforêt as our general counsel, and he did a lot of the groundwork, the legwork, and the writing of the draft provisions that we would meet monthly and review, meet monthly for a long weekend and review. And finally, much to everyone's surprise, within the year that we were given to do it, we had it done and presented it at the annual meeting of the Canadian Bar. I think it was in 1978. It was in Halifax anyway, and I think it was in 1978. And that document basically became the Canadian Constitution that was proclaimed, I think, in 1982. I think it was 1982. We made one mistake, was that we recommended that the role of the Queen be abolished and that the country become a republic. And that caused such consternation among the bulk of the profession that it sort of overshadowed the rest of the work of the rest of the work that we did on the Constitution, most of which can be found in the Constitution of Canada now. But that was a very interesting committee. There were Clyde Wells, who later became Premier and Chief Justice of Newfoundland, and Joe Giz, they became Premier and a judge in PEI, were members of the council. Yves Fortier became Canada's ambassador to the United Nations, who was a member of George Finlayson, became a member of the Court of Appeal of Ontario. It was really a high-level committee, and I was pleased to be able to be a member of it.
So do you have comments on how the practice of law has really changed over the years, for the better, for the worse?
Well, it's hard for me to say because I haven't practiced for 40 years.
True.
So all I really know is what people tell me, and including you, and friends, lawyer friends from around town here. So I gather it's the big change is billable hours. I think when I started, we didn't keep hours. Everything was done on a lump sum basis. You estimated, first of all, how much time you put in it, and then you estimated how able the client was to pay. There was no legal aid then, and so a lot of the work was done pro bono. There was sort of an informal legal aid, particularly for doing police court work, as I did quite a lot of at the beginning. So, and I think that's one change in the profession is much more business-oriented than it used to be. And also, I think lawyers specialize at a younger age now than they used to. Again, I was probably did more litigation than most lawyers in the province, but still, well, the most would be Don Gillis and Neil McKelvey, but the profession today seems to be more lawyers seem to specialize earlier and more focused specialization than now than it was. For example, it was felt, I think clients felt and lawyers felt that if you could defend someone on a speeding charge, you could use the same aptitude to defend them on a murder charge, or indeed draw a will. And, the clients didn't expect you to be a one-trick.
And certainly technology has been, has had a huge impact too over the years. So I am kind of watching the clock here. So I think what we're going to do, if you wouldn't mind, is I'd love you to talk about your last assignment. I call it the capstone of your career. You being asked to be one of the three Commonwealth judges that sat on the Bloody Sunday inquiry. So maybe tell people how that came about, how you were chosen, why you were chosen, how it proceeded. It was a mammoth undertaking, which took way longer than any of us thought it would. And maybe just talk about Bloody Sunday.
Well, but the Bloody Sunday inquiry was set up by the British government in 1998. There had been a previous judicial inquiry into the event which had happened in January of 1972. And the former inquiry had its hearing and published its report, I think in April or May, or June perhaps at the latest, of that same year. So it was done very quickly. And its conclusion was never accepted by the families of the victims of Bloody Sunday, which I probably should have mentioned for those that are not aware what Bloody Sunday was, a nickname given to a series of shootings in Londonderry, Northern Ireland, when the British Army opened fire on a huge crowd of demonstrators marching in protest against policies of the British government in Northern Ireland. 13 people were killed and 13 or 14 were injured at that time, all within a 20-minute period. And as I say, there was an earlier inquiry conducted by the Lord Chief Justice Widgery, and he basically put not all, but almost all of the blame on the civilians for having caused the British Army to do the shooting. It was never accepted obviously by the families of the deceased and by a lot of others. And as part of the peace process, the so-called Good Friday agreement that Tony Blair struck with the Irish government and the IRA in 1972, in 1998, it was agreed that there would be a new inquiry into that event. And there was not a controversy, but quite a time about how the inquiry would be constituted. The Irish government and the families wanted it to be completely independent of the British government and wanted a truly international committee to do the inquiry. The British government, of course, couldn't agree to giving up sovereignty, legal sovereignty, over part of their own country. So it was decided that the British government would constitute the committee under their Inquiries Act and appoint a chairman, whereas 2 Commonwealth countries would each nominate a judge, who would be appointed by the British government in the usual way. So it would be a UK inquiry, but composed of 2 Commonwealth judges and 1 British judge. That way they avoided the problem of having an inquiry with no legal recourse to govern its operation, and at the same time gave it an air of independence by having 2 Commonwealth judges, 2 of the 3 non-British judges on the inquiry. It turned out to be a wise move because we were judicially reviewed a number of times in the British courts, and that remedy wouldn't have been available, of course, if it had been a truly international inquiry, because there would have been no home court for the judicial reviews to be held. So that's how it got set up. It turned out, of course, as we all know, to be much longer than we had anticipated. There were I think there were 2,500 witnesses that were interviewed, potential witnesses that were interviewed, statements taken, and at the hearing itself, over 950 witnesses were called. The report was finally 12 years before it was delivered, and was consisted of 4,500 pages of text plus appendices. The interesting thing, one of the interesting things was the technology involved at the time. At the time, there was computers were just making their way into courtrooms, and fortunately, our chairman, Mark Saville, was a computer enthusiast and head of the British Judges Computer Institute. So he used his influence and his knowledge to set us up in a very, very
high-tech way.
Experience. I have here, I don't know whether it'll show up or not on the screen. I'm sure there's a picture. I don't know if that shows up or not.
Pull it back a little bit, Dad. Just pull it back a little bit. So I think this is a picture of the Guildhall. Back. So yeah, that's a picture of the Guildhall where all the hearings were held in London, Derry. You can see, leave it up, Dad, for a minute. You can see all the counsel and judges kind of at the below, and then there was this huge TV camera. That's Mark Saville there. That's on the TV screen. So whoever was speaking, they were projected onto this huge screen. I'm sure Dad will tell you, but I think all the evidence was taken in real time.
That's right.
And you could retrieve it in real time.
So it had every sort of modern convenience known to the tech world in 1998. It probably is quite commonplace now. But as you said, we had instantaneous transcription. We had closed-circuit television that piped the hearings into a local theater where the overflow audience went, or people that didn't want to come to the Guildhall for any other reason. they had the opportunity of going to a theater to watch it. The transcript was posted on the internet within 2 hours at the end of the hearing each day, and each lawyer had his own screen and monitor, and the exhibits, when exhibits were mentioned, within a fraction of a second, they would appear on all the monitors for the judges and counsel and the spectators, of course, as well. So the hearing itself, I think I forget now exactly how many days we sat. I think it was 400 and some days we sat, and then spent the rest of the time. We didn't start sitting until 2002, the fall of 2000, the fall of 2000, and we finished our sittings in 2003, and for the next 6 years to the court. I think that's all I wanted to say about the inquiry. The courtroom itself was the Guild Hall in Derry, a rather grand building that really, if you can see that photograph, showed up very well when it was transformed. By the way, we sat for 1 year in London because the soldiers were afraid to give their evidence in London. They're afraid of reprisals, unnecessarily in my view. And that was one of the judicial reviews. We were ordered by the British Court of Appeal to take the soldiers' evidence in London because of their fear of reprisals if it was taken in Derry. So we had a duplicate courtroom set up in, not quite duplicate, but a different building, the Methodist Church Hall in London. We set it up, replicated in every way except the building itself, the courtroom that we had in Londonderry, with all of which, of course, added to both the expense and the time of the inquiry.
So is there anything you want to talk about or say that we haven't covered or I haven't asked?
No, not really. We skipped over the cases in the Court of Appeal quite quickly, but they weren't, of course, they weren't as interesting as either the trial court decisions or the decisions when I was a judge.
Do you want to take a couple of minutes and talk about one or two?
Well, of course, no, I don't think. We again had a lot of interesting cases, but I think the Legier case was one of them. That was the first time that DNA evidence was sanctioned for use or found to be admissible evidence in an appellate court in Canada. I believe that to be the case. There was a Blah case about marital women's division of assets on marriage breakdown. There was the Walker case about whether a young underage Jehovah's Witness could refuse medical treatment. There was the lot of still was probably the most talked about. It was whether you could use conscripted evidence against an accused in a murder case, or in this case, murder. And we were reversed in that particular case by the Supreme Court of Canada, although they have sort of moved away from that and have basically adopted our reasoning in Stillman, our original reasoning in Stillman. So there were just too many cases, I think, to got sat on 1,200 cases in the Court of Appeal in 13 years. And so there are bound to be a couple of interesting ones in that number.
That's great. So I think we'll end it there. Thanks for doing this, Dad. It was terrific. I hope everyone enjoys it. And that's it. Thanks.
So enjoying reminiscing.
Well, thank you very much.
Okay.
Bye-bye, everybody.